This is Mr. Valentine, whose matters, I believe, are at the end of the calendar, numbers 26, 27, and he has declined counsel and would like to proceed on his own. I believe
so Mr.
had been this matter before.
Yeah, Mr. Valentine, you had an attorney appointed, and then you didn't come back the way we needed to come back way back in March. So you got an attorney sitting there, an experienced criminal defense attorney, might help you. Would you like to take the advantage of having Thurston County Public Defense represent you again?
No, ma'am.
Can you tell me why?
Because I would like to proceed sui juris, because I believe I have my best interests, and I don't think anyone else in this court has my best interests for me.
Before we even get into the courtroom fireworks, let's talk about who you're watching right now. This isn't a first-time defendant who wandered into court confused and scared. This is a seasoned sovereign citizen who has clearly spent a lot of time on the internet convincing himself that magic words, misunderstood legal terms, and imaginary contracts can somehow override DUI charges, arrest warrants, and basic reality. He's facing serious allegations, multiple cases, and real jail time, yet he's walking into court convinced that calling himself a living man, instead of a person, is going to unlock some kind of legal cheat code. And that mindset is exactly what makes this case so dangerous, not just for him but for everyone else on the road. Over the course of these hearings, you're going to watch judges repeatedly try to help him, warn him, and even protect him from himself, while he does everything in his power to derail his own defense. Pay attention to how often the court offers him counsel, how often he refuses, and how quickly his arguments collapse the moment they're challenged. Because this isn't just a courtroom, it's a slow-motion demonstration of what happens when confidence replaces competence.
Okay. All right. Well, first, there are a couple of warrants. I'm going to turn to the prosecuting attorney, Mr. Abid, first, and see what their recommendation is on this warrant return, and then I'll turn to you. So I'll just allow you to represent yourself today as you want to. Mr. Abid?
Your Honor, the state would object to releasing Mr. Valentine, and the alternative, the state asks that the court set substantial bail on both of these matters. The first one, ending in the cause number 693, is a case, is an old case. Mr. Valentine, I'm seeing, has substantial failure to appear history. This is here's sorry, Your Honor. Mr. Valentine was on warrant status for a significant period of time. In March, the court issued a $15,000 warrant on each case. The court, Your Honor, or the state, Your Honor, asks that the court impose bail in the same amount as the warrants.
And this is first DUI from November of 2021, and then the second allegation, January of 2024.
Correct.
And were these, one, it appears, was an allegation of a breast sample of 0.14, and the other from 2024, do you know the allegation?
My notes show that the 2024 allegation was included a refusal.
Okay. All right. So, Mr. Valentine, what the state's asking me to do is have you post about $30,000 cash or a bond bail, and consider those same restrictions that were on you before, that you show up at pretrial services, that you stay clean and sober, you stay law-abiding, you give UAs, you be on a device that's attached to your person to make sure you're not consuming alcohol. What do you have to say?
I object to that, Your Honor. I did make my best effort to show up at court, even when I didn't show up, because I was confused about the dates. The clerk told me the wrong date. I showed up. I gave the clerk a letter. I wrote a letter to the court, and I also wrote counterclaims and responses to the state attorney general's office, and I got no response from either. I went to try to squash the warrant. They told me that they wouldn't squash the warrant. They wanted me to either turn myself in, or they wanted to get me to pay more bonds. I have absolutely no problem showing up and representing myself. As far as What was the next thing? As far as these charges that are against me, I wanted to be clear that I am not a person. I'm not a legal entity. I'm a living man, and I want to enforce my constitutional rights. I have the right to drive without a license. I don't need a license. The Supreme Court has proven that many times. And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi. If the prosecutor has a valid contract between us, I would like him to produce it. If not, I do not wish to contract with any members of this court.
This exchange right here is one of the most important moments in the entire video, and it's something viewers should really take seriously. Judges do not casually beg defendants to take lawyers. When a judge goes out of their way to use analogies, humor, and blunt honesty like this, it's because they see a train wreck coming and they're trying, unsuccessfully, to stop it. The court is laying out a fundamental truth. Criminal law is not a DIY project. You don't get bonus points for independence, and the system does not bend because you think you're smarter than it. What's especially telling is that Mr. Valentine frames this as a trust issue, claiming no one has his best interests at heart, while ignoring the fact that a public defender's entire job is literally to protect him from outcomes like prison. This is classic sovereign citizen thinking, rejecting expertise while overestimating personal understanding. And the irony? By refusing counsel, he's giving the state exactly what it wants. A defendant who doesn't know how to properly object, preserve issues for appeal, or protect himself from his own statements.
And it is also my understanding that this is a Nisi Prius court, and I would like to implement Rule Nisi.
Well, Mr. Valentine, I'm going to hold you on $15,000 cash or bond bail on each of these independently. So you'd have to post bond to be released, as I find that you're a risk to reoffend and a risk to commit, another DUI or vehicular assault or homicide, given the history while under the influence. So you're a danger to the community is what I'm finding. And you don't come back when we order you to come back, and you don't comply with court orders. So $15,000 cash or bond has to be posted on each one of these separately. And then you have to get yourself into pretrial services within 48 hours of release and have a scram device attached, stay clean and sober, stay law abiding, in order to stay out of custody. No alcohol, no marijuana, no non-prescribed drugs, no bars or taverns. And don't drive unless you have a good license and proof of insurance. I'm going to set another court date. We would do this.
What jurisdiction is this court operating under, Your Honor?
Thurston County District Court here in the state of Washington.
Or what jurisdiction are you trialing me under?
What jurisdiction? Thurston County District Court, Thurston County, state of Washington.
That's not what, is this under a common law jurisdiction?
I'll have you research all that yourself, sir. I'm not going to argue with you. I have jurisdiction over you and over this matter.
So is this court operating common law, ma'am?
I'm talking to my clerk. 1 second. And make it clear, good, that he's proceeding pro se and that we need to do it.
I am not pro se. I'm a seri juris.
All right. You're proceeding without an attorney.
Did you take an oath to uphold the Constitution of the United States, ma'am? The supreme law of the
I
land?
sure did. I take it every time I get reelected, and I take it very seriously. Very seriously.
Are you going to be honoring that
No,
oath
it's
today,
just
ma'am?
free trial, and then we'll get it set for confirmation and jury dates.
Are you honoring that oath today, ma'am?
I sure am. And I do it every day.
So you think I'm a person?
I sure do.
So you think I can be bought and sold and regulated? You think I'm a persona, that I live in the likeness of another?
This is where the case quietly shifts from eccentric defendant to serious public safety issue. The prosecution isn't asking for high bail just because they don't like this guy. They're laying out a documented history of failures to appear, outstanding warrants, and repeat DUI allegations. Courts don't impose restrictive bail conditions lightly, especially when they involve sobriety monitoring and scram devices. Those measures are reserved for defendants who have demonstrated, through their own actions, that they cannot be trusted to follow basic court orders or stay off the road while impaired. Notice how the judge carefully explains what's being requested. Not punishment, but prevention. Stay sober. Stay law-abiding. Show up. And instead of engaging with those concerns, Mr. Valentine immediately pivots to excuses, clerical blame, and paperwork he claims no one answered. That deflection is important, because it shows a refusal to accept responsibility, which is exactly what judges look at when determining whether someone is a risk to reoffend.
I think you're a human being and you're covered by the laws of the state of Washington.
A human being and a person are two different things.
No, I'm not interested in semantics. So
I'm trying to get down to the facts, man.
you can define things the way you want, but the law is not agreeing with you. All right, we're going to be back on September 20th, 1:30. We'll probably talk some more about your decision to represent yourself, and that's fine. But don't be surprised if whichever judge is there has another discussion with you about that. And at any time, you can ask the court to appoint an attorney. Anytime you can hire an attorney to represent you too. You're not prevented from that.
One attorney.
So we'll be back on September 20th, and you need to be back in court. If you're still in custody, we'll hear you in custody. And if you do post-bond, you have an obligation to get into pretrial services within 48 hours and comply with them for sobriety monitoring. And that substance use monitoring program will pay for the Scram device.
Can we change the venue, ma'am, for lack of jurisdiction?
Well, you'll have to file all your motions in writing, and then you serve them as well on the prosecuting attorney, and then we'll set motion hearings.
I don't have the resources to do that in custody, ma'am.
I think you do.
I don't. There's not much paper here. There's no computers I can use, no printers. They're not giving me post stamps.
Offering you Thurston County Public Defense's assistance, I could.
Deny the right to defend myself. You want me to hire someone else to do it? I'm not
denying that, and I'm not going to argue with you, sir. So, at any time, we can talk about standby counsel, we can talk about counsel.
Everyone represented. I will continue to proceed sui juris.
All right, that's up to you. I'm doing that. All right, so we're done today, and those orders will be given to you in the jail.
All right, I don't consent to any of those orders.
This right here is sovereign citizen bingo in real time. I'm not a person. I'm a living man. Produce the contract. I don't consent. These phrases get repeated endlessly online, but courts have heard them thousands of times, and they fail every single time. What makes this moment especially brutal is that the judge calmly dismantles the argument without raising her voice or entertaining the fantasy. Jurisdiction exists because of conduct, not consent. Driving on public roads while intoxicated isn't a philosophical debate. It's regulated behavior with consequences. And the attempt to misuse legal terms like nisi prius and Rule N only highlights how surface level this understanding really is. He's trying to sound sophisticated, but ends up proving the opposite. The court isn't confused. The law isn't confused. Only one person in this exchange is, and unfortunately, it's the one making decisions that could cost him years of freedom.
And folks, I'm guessing you're all here for the same case, since you're all sitting shoulder to shoulder. What case are you here for? Okay. And Ms. Moore, is Mr. Valentine, is that Mr. Valentine with you by chance?
Yes, it is.
This is Mr. Valentine,
Okay.
Your Honor, wishes to proceed without counsel.
Okay.
First of all,
Yeah, hold on. I'll let you know when I need to hear from you.
okay.
So, Ms. Moore, has your office appointed somebody to replace Mr. Gaslin?
Your Honor, we were not appointed at the last hearing, and I'm not asking for appointment today as Mr. Valentine is declining representation. I have advised.
Okay, I'll take care of it. Thank you. Mr. Valentine, as Ms. Moore has indicated, you've told her you want to represent yourself. I'll tell you that's a huge mistake. I will treat you like you graduated from law school. I'm going to guess that because you're sitting there next to Ms. Moore, you have not graduated from law school, but you will be treated as if you had, which means I will expect you to know everything that I expect every lawyer to know. I will expect you to do the things that I expect every lawyer to do. I will expect you not to do any of the things that a lawyer is expected not to do. All that means that you haven't been trained in those areas, and yet I'm going to hold you to those standards. You would be making a bad mistake if you represent yourself, particularly because with two cases like this, you're probably looking at potentially up to 2 years in jail. So it's really important that you have good representation. If you were there, even if you had been trained as an attorney, I would say do not represent yourself. Lawyers know not to represent themselves. And there's a saying among lawyers that if you ever get charged with a crime, lawyers will say, it's a fool who represents himself. That is, even though they're trained to do that. So I would strongly recommend you not do that. You have the right to do it. I'll be very clear. I think you would be making a huge mistake should you do that. Do you have any questions about that? Do you have any questions about that?
Are you attempting to intimidate me under the color of law?
This exchange perfectly captures the philosophical dead end of sovereign citizen ideology. On one hand, Mr. Valentine insists he's not a person, yet in the same breath demands constitutional protections that only apply to persons. And the judge delivers a line that should end the debate instantly. Objects don't have rights. You can't opt out of legal status while demanding legal benefits. You can't reject regulation while using public infrastructure. And you definitely can't argue semantics when your actions, driving, refusing sobriety tests, failing to appear, place you squarely under the court's authority. The judge's refusal to get dragged into word games is intentional. Courts don't argue definitions endlessly because the law is applied through conduct, not personal belief systems. This moment isn't about winning an argument, it's about reality colliding with ideology and reality winning every time.
Do you have any questions for me? Other than that? No, I'm not in tempt. I'm trying to make it very clear to you that I think it's a big mistake.
I'm ready to proceed.
Okay. All right.
First of all, I would like to address we the people, and I would ask that they would all stand for a moment.
No,
People of
just
special appearance.
If viewers needed confirmation that this isn't just one judge being impatient, this is it. A completely different judge, same courtroom reality, same conclusion. Representing yourself here is a terrible idea. And this warning is even more explicit. The judge makes it crystal clear, you will be held to the same standards as a licensed attorney, without the benefit of legal training. No coaching. No special treatment. No leniency for mistakes. That's not intimidation, that's transparency. And when Mr. Valentine responds by accusing the court of acting under color of law, it becomes obvious he's not listening, he's performing. This isn't about defense strategy anymore, it's about ego. And courts don't bend to ego. They document it.
no. We're not doing anything like that. We're here on a pretrial. You have a confirmation hearing set for the 18th of October. Mr. Valentine, you have anything to say about that status? Otherwise, we're just going to close the hearing and move to that date.
I'm going over judicial notices that I've submitted to the court.
Okay. This is not a motion hearing. This is just a procedural hearing. And we'll just close out this procedure or this proceeding and confirm that your next court date is the 18th of October. If you wish to file a motion, you're going to have to do so in the appropriate fashion and get it before the court. It's one of those things that I've told you. It was why I advise you not to proceed representing yourself.
I have filed judicial notices with the court.
Okay, thank you. We'll set a motion hearing and have consideration of those. Thank you.
The presence of family in the courtroom adds a quiet but powerful layer to this case. While Mr. Valentine treats the hearing like a stage for declarations and objections, everyone else understands what's actually happening. Deadlines are being set, trial dates confirmed, and consequences locked in. Procedural hearings may sound boring, but they're where cases are won or lost. Filing motions correctly matters. Meeting deadlines matters. Understanding what a hearing is, and isn't, matters. And every time the judge has to explain basic procedure, It reinforces the same point made earlier. This is why lawyers exist. Watching someone insist they're in control while the process moves forward without them is uncomfortable, but instructive. The court isn't waiting for belief, it's proceeding with law.
Hi, folks. I don't want to hear any comments. None. So 18th of October is when he's due back.
And that's set for trial confirmation, Your Honor?
It's set for trial confirmation.
Thank you, Your Honor.
And Amy, if you'll make a note to...
I object to that. You're not allowing me.
We'll note your objection.
We need to get you unmuted.
Yes, ma'am.
All right, so there are a couple of attorneys sitting behind you from Thurston County Public Defense. Did you want the court to appoint counsel or not?
No.
Were you going to hire your own attorney on the matter or represent yourself?
I've made it clear throughout all these proceedings that I'm proceeding sui juris.
Okay, I just need to always make sure of that. We've got confirmation set for the 8th. What is it today that you want to do?
I wanted to argue in some motions that I submitted to the court. A motion to dismiss, a judicial notices that I've dismissed about misconduct of the court and denied of access to the court. And I believe a motion to strike as well.
Motion to strike what?
It was a motion to strike. You guys had served a motion, no testimony to my house. I'm not sure what that was. The motion was never served to me, and the docket was never served to me either. It was mailed to my home. I'm not sure why, because the state was aware that I was in custody, but that's what my motion to strike was pertaining to.
Okay. Well, this is your motion today, and motion no testimony just means we didn't expect to see witnesses being called to the stand. So let me hear from the prosecutor here.
It's
Mr.
the state's
Weston?
understanding that the motion to request discovery and the motion to dismiss was heard on October 28th in front of, I believe, Judge Buckley, and he dismissed those motions. And the state's understanding is that the only motion that was going to be argued today was whether the court should grant funds for Mr. Valentine to hire an investigator.